What's up, everyone? My name is NINAAD and I'm a legal intern at LEXIS and Company, and I'm also a student of the Maharashtra National Law University, Mumbai. In today's video, we're going to be talking a bit about the need and necessity of pre-incorporation contracts and the challenges related to it while the formation of a company is taking place. Now, while it constitutes all of its members, a company itself is always known to have its own separate legal identity that is distinct from its members. This provides the company as an entity with the power to enter into contracts in its own name as well as to acquire certain contractual rights and obligations ensuing from these contracts. But as such, being an artificial person, the company itself cannot enter into any such contracts before its own formal establishment. Even to establish itself and start its business, it needs to go through several contracts and incur several initial expenses as well. But as I've already mentioned, they cannot do it for themselves without any formation or formal establishment of their own. Hence, these become designated jobs for people who are known as promoters, who are tasked with giving birth to the company, as such, bringing the company into valid and proper legal existence. These promoters have the authority to enter into a contract with third parties even before the registration of the companies. Such contracts, which are entered into by promoters with these third parties to acquire some sort of property or right on behalf of the company that is yet to be formed, are called as pre incorporation contracts. Now, these contracts are considered valid in the name of the promoters and are very necessary to ensure that the company is properly incorporated and is successfully operational and continues running without any sorts of problems or any sorts of difficulties. Now, such contracts are hence very inevitable for the registration of companies. In India, these contracts are recognized by the Companies Act of 2013 and the Specific Relief Act of 1963. More specifically, the validity and foreseeability of pre-incorporation contracts lie in Section 15 and Section 19 of the Specific Relief Act of 1963. But even with due recognition, the actual legality and value of these contracts in India is somewhat difficult to pinpoint. The foremost and the most basic argument in this matter is that a non existent entity like a non formed company cannot form contracts or even be the principal and appoint an agent to do any sorts of work for itself. As such, all contracts made by promoters would impose liability on the promoters themselves. But Section 230 of the Indian Contract Act states that an agent is not entitled to legally enforce any sort of contract that has been entered into by them on behalf of their principal, nor are they personally bound by them if they specifically state at the time of the making of the contract that they are only acting as an agent and that they are not and will not be personally liable under the contract. So, if this principle is applied, the contract becomes redundant as neither of the parties is liable under the contract. On the other hand, Section 15H of the Specific Relief Act of 1963 reads that wherever a pre incorporated contract is entered into by promoters for the purpose of the company and subject to terms of incorporation of the company may ask for specific performance from the third party. But this condition can only be applied if, when after being incorporated, the company expressly demonstrates acceptance of the contracts that have been entered into before its formation and communicates the same to the third party concerned, that is the other party that the promoters have formulated the contract with. Under similar circumstances, the other party to the contract under Section 19E of the Specific Relief Act may also further enforce specific performance under the company. Thus, in order for the company to actually be able to enforce the contract against the other party to contract, the members must be ratifying the contract followed by communication of acceptance. The company may not be able to receive any benefit from such a contract unless the contract is accepted by the company, and the promoters would become personally liable for the contracts. In the event that the company does not accept the said contract at its meeting, such contract is indeed binding on the promoters, and both the promoters and the third party may demand specific performance against each other. But even the scheme of ratification does not come by without its own challenges. Firstly, in cases where the company shows reluctance in warranting the terms of the contract or has refused to warrant the terms of a contract. Now, if a company does not ratify the pre incorporation contract, then all the parties are pushed into a corner with no remedy at all, as there is no background so as to what is to be done in such a case. Secondly, even if the company does ratify the contract, the provisions allowing such ratification would fail to show and justify the fundamental and foundational jurisprudence of the contract law and company law. If the legal base of such ratification is Section 196 of the Contract Act, then as per the law, the act itself, done on the behalf of another person, gets ratified and the relationship of principal and agent is automatically thereby created. Since a promoter is neither an agent nor a trustee, it becomes unclear how the provisions related to agency law are or can be specifically applied in this case. The position of the promoter itself is quite peculiar as it holds the position of sort of a quasi trustee and not completely a trustee. Thirdly, in cases where a contract has already been ratified, it may be admitted that Section 196 of the Contract Act gets applied, but the agency created then would lead the enforcement rights of the promoter to fall under two dichotomized provisions that are Section 15H of the Specific Relief Act and Section 230 of the Indian Contract Act. The effective operation of the former one will make the contract enforceable only against a third party, whereas in case of the latter one, the contract will not become enforceable at all as per Section 230 of the Contract Act, which states that an agent cannot be sued unless there is an agreement contrary to that effect. Lastly, even if a company ratifies a pre-incorporation contract and in case such contract falls outside the object clause under the memorandum, then it would become ultra virus and such contract would then be rendered void and unenforceable even if all shareholders give assent to it. As such, these pre-incorporation contracts are a legal necessity. The kinds of challenges they face are a pointer towards the need for our legislature to come up with relevant solutions as well as appropriate policy reforms. Among other things, these policy reforms need to clarify the positions of both the promoter and the third party in absence of subsequent ratification by the company, and also cover up for the loopholes created by conflicting legislations. It must hence strive to provide remedy to both promoters as well as third parties to prevent any sorts of failure of justice. The judiciary is also required to do its part and move away from common law practice in this regard, since common law practice itself is riddled with various flaws. That is all for this video. If you learned something from it, do definitely like, share, and subscribe. Do comment down below any questions, suggestions, opinions, or queries you might have regarding the video. That's all. Thanks for watching, and I hope you have a good one.